You picked the name, you bought the domain, you built the Instagram, the website, the offer. You've been showing up, posting, pitching, building, and people are starting to know who you are. And I'm going to tell you something that most attorneys are not saying loud enough. You don't own your brand name yet. Not legally, not in a way that actually protects everything that you're building. And today I'm going to show you exactly what that means, why it matters more than you probably realize, and what you need to do about it. In plain language, with no gatekeeping, no legal jargon that has you more confused than when you started. There's this belief that's incredibly common in the online business space, and it's so deeply embedded that most people never even question it. And the belief is this: if you're using your business name, you own it. That couldn't be further from the truth. And I don't say that to be harsh. I say it because everybody that talks about starting a business, they typically miss this point. And I watch women build incredible things on top of a foundation that they don't legally own. And that gap, that invisible vulnerability, that's what I'm here to close. Here's what's actually true. In the United States, there's two kinds of trademark rights. There's common law rights, which exist automatically the moment you start using the name in commerce. And then there's federal trademark rights, which only exist when you file with the USPTO and get approved. Most entrepreneurs have the first kind. Almost everyone assumes that they have the second. Common law rights do give you something. You can use the TM symbol. You do have some baseline protection in the area that you're using the name. And in a dispute, you may be able to prove that you were using the name first. But here's where it falls apart. Because a common law trademark is unregistered, it's not part of an accessible database, meaning the USPTO won't consider it when they're evaluating someone else's application. So if someone files for a trademark application for your name right now, the USPTO won't automatically find your use. They won't flag it, they won't stop it. That person could get approved, and now they have a federal registration, which gives them nationwide rights, while you're left trying to prove with screenshots and receipts that you were there first. Common law trademark rights can be hard to enforce because there's no public record of your trademark or when your trademark use began. Using your name built your brand, but it didn't protect it. Those are two completely different things, and understanding the difference is where real brand ownership begins. Now let's talk about the other thing that people lean on when they feel like they've handled their legal foundation, and that's the LLC. I get some version of this question constantly, and I want to answer it clearly and completely right now. But I have an LLC. Doesn't that protect my brand name? No. And I need you to hear this fully before we move on. Your LLC is one of the most important things that you can have as a business owner. It creates a legal separation between your business and you personally. If your business ever gets sued, your personal assets like your car, your house, and your savings, they're all generally protected. And that matters enormously, so please have an LLC. But your LLC doesn't give you exclusive rights to your business name. Registering your business name in your state creates rights only in that state. And most of you are not just operating in one state. Your Instagram followers are in every state, and I'm pretty sure your digital products are selling nationwide. Your brand lives on the internet, which has no geographic boundaries. Someone in another state could right now be building a business under a name that's nearly identical to yours. Your LLC does nothing to stop that. Your state business filing does nothing to stop that. Only a federal trademark registration gives you nationwide protection. Think of it this way: your LLC is the legal container that your business lives in, and your trademark is the legal ownership of the name that's on the door. You need both, but they're not doing the same job. And confusing one for the other is exactly how you end up with personal liability protection with zero brand protection. So file your LLC, but don't stop there. Here's a part of the conversation I want you to sit with. There's a window in your brand building journey, a critical period between when you start and when you start seeing real visibility, where filing a trademark is the highest leverage, lowest drama move you can make. And most entrepreneurs miss it entirely, not because they're careless, but because nobody told them it existed. Here's how it usually goes. You start your business, you choose your name thoughtfully, you search Google, you check Instagram. Nobody obvious is using it. You start building, you get traction, your audience grows, the content is working, people are really starting to know your name. And then one of two things happens. Either someone else sees your growing brand, notices that the name isn't registered, and files a trademark before you do, or you finally decide you are ready to file and find out that somebody else already has. Failing to register your trademark may lead to loss in trust in your community, force a rebrand, or significantly hinder your ability to expand your business. Let me make that concrete for you. Losing your brand name means losing your domain and every piece of SEO equity attached to it. It means changing your social media handles and starting your searchability from zero. It means that every dollar that you spent on content, marketing, and advertising, pushing people to that name that you can no longer use, is wasted. And it means the emotional cost, the loss of the thing that you built, the audience that knows you by a name that's no longer yours. And I'm not telling you this to stress you out. I'm telling you this because I believe in giving you the full picture, the real information that lets you make the real decision. Another business could register a similar mark federally or have stronger common law rights elsewhere, limiting where and how you're able to grow your business. The best time to file is before you have the visibility, before the big audience, before your name is big enough to attract conflict. Because the moment that you have all of those things is the moment moment that your risk becomes the highest. Like I always say, proactive will always cost less than reactive in time and money and peace of mind. And if you're watching this and realizing that my legal foundation needs some attention, I put together a legal launch and protection guide specifically for those who are building and want to do it right from day one. And it covers exactly this, the legal steps you need to take in the right order before you need them. No overwhelm, no jargon, just a clear roadmap. I'll leave a link in the description. Now let's talk about what's actually on the other side of this, because this isn't just about protection. This is about power. A federal trademark registration is a business asset. And when I say that, I mean that in every sense of the word. Here's what you actually get. Nationwide rights day one of your registration. Registering your trademark with the USPTO creates rights throughout the entire United States and its territories. Not just where you live, not just where you've been operating, but everywhere that you want to grow. You also get the legal presumption that your mark is valid. Owning a federally registered trademark is considered evidence that the mark is valid and that the owner has exclusive rights to use it in commerce, which means in a dispute, you don't have to prove your rights. Your registration proves it for you, and the burden shifts to the other side to prove otherwise. That is not a small thing. That's an enormous strategic advantage. The R symbol and everything it signals. The R symbol identifies federally registered trademark rights recorded with the USPTO. That symbol tells every competitor, every copycat, every brand that's watching you that this name is taken legally, officially, with federal backing. It's a deterrent before a dispute ever begins, and federal court access for enforcement. A federal registration gives you the right to bring a lawsuit concerning your trademark in federal court. So when the stakes are high enough that you need real enforcement power, you have it. And something most people don't think about at this stage. A registered trademark enhances the value and goodwill of the business, provides more credibility to consumers, and may add value to the business in the event of acquisition or merger. You're not just protecting what you have today, you're building an asset that holds value, something that can be licensed, acquired, and passed on. That is generational wealth thinking. That is the long game, and you're allowed to be playing it from wherever you are right now. Now I want to talk directly to the women who are watching this and thinking, okay, I need this, but I've been putting it off because I don't know where to start. It feels expensive, or I don't think my business is big enough yet. You are big enough, and you've always been big enough. And this process, when broken down simply, is way more accessible than the legal industry has led you to believe. Here's how it actually works. Step one, conduct a trademark search. Not a Google search, not an Instagram handle check, a comprehensive search of the USPTO's database to find out whether your name is legally available and whether there's any existing marks that may cause conflict with yours. This step is a non-negotiable. Filing without the proper search will have you spending real money on an application that gets refused because you didn't know that there was a conflict to begin with. Step two, confirm your name is actually protectable. The USPTO has specific standards for what qualifies for trademark protection. Names that are too generic or purely descriptive face significant obstacles. The strongest trademarks are distinctive. They're brand identifiers, not just descriptions of what you do. This is one of the most important reasons why working with a trademark attorney is worth the investment, particularly when your brand name is the thing that everything else is built around. Step three, file in the right class. There are 45 international trademark classes covering different categories of goods and services. Filing in the wrong class will create gaps, and filing in unnecessary classes wastes money. The right filing strategy matters more than filing fast. Step four, respond to any office actions. After you file, the USPTO will examine your application, and sometimes they do issue an office action, which is a list of questions or issues to address. This is a normal part of the process. It's not a rejection, it's a conversation, and navigating it correctly is what will get you approved. Step five, maintain your registration. Your trademark registration can last forever as long as you continue to use the trademark in commerce and you provide evidence to the USPTO of that use at the required intervals. Miss those maintenance filings and your registration can get canceled. So know when they're coming and handle them. This process typically takes 12 to 18 months from filing to approval, sometimes longer, which is exactly why the time to start isn't when you feel ready, it's right now. Because by the time that you feel ready, you're already a year and a half behind where you could be. Let me make this as concrete as possible. You just launched. You love your name, but you haven't filed yet. Start with a trademark search this week. Don't invest another dollar into building around a name that you don't know is legally available yet. You've been in business 1 to 2 years and building consistently. For you, filing is urgent. Your common law rights give you a foundation, but they're not protecting the nationwide brand that you're building. Federal registration is what secures what you built and what you're building towards. You have a real audience, a product suite, and brand recognition, but still no trademark. You need to move now. The more visible you are, the higher the risk. And the more you have built, the more there is to lose. You have signature programs, a core source name or framework that you've built your reputation around. Each of those names may need its own protection. A trademark attorney can help you prioritize strategically so you're protecting the right things in the right order. Here's what I want you to carry with you from today. You've worked hard for this. You've showed up for the days that it felt easy and for the days that it didn't. You've built something with your name on it, literally. And you deserve to actually own it. Not just use it, not just build on top of it. Own it with the legal protection that makes that ownership real and enforceable. Too many brilliant women, especially women of color, are creating in public. They're growing audiences. They're launching products. They're building legacies on a legal foundation that was never fully secured. And they find out what that means only after something goes wrong. That doesn't have to be your story. The information exists, the process is accessible, and you're more than capable of building something from the ground up. You now know what owning your brand name actually means. You know the difference between common law rights and federal registration. You know what your LLC does and what it doesn't do. You know what's available to you on the other side of filing. Now use it. If you're ready to stop guessing and start building your business the right way, watch this next video. If you have not subscribed yet, do that now because this is your weekly legal strategy session and you don't want to miss what's coming. Drop your questions in the comments. I read every single one. Thank you guys for watching. I'll see you in the next one.